Okay, excellent. Welcome, everyone. This is Kianga, your moderator for the Regenerative Finance Constitutional Voter Committee. We are a group of MKR holders organized under the new endgame, pre-game constitutional rule set, a whole new future for MakerDAO that's evolving rapidly. And this is a meeting that we hold once a week to discuss two things. I mean, kind of two broad things. We've got some responsibilities, some governance responsibilities in the new endgame structure. And part of that is to tackle a broad theme of physical resiliency. In this particular call, we're going to take a break from discussing a lot of the meta governance details we've gone into in the past couple of weeks. We also want to explore how this meeting time, when we're all coming together live on Voice, can be a forum for things other than discussing the specifics of scope language or internal maker policy. And so with that, a little bit of an intro for what we're going to do today. We've invited someone that's been very active in the maker community. I, in my past life as a delegate involved here over the past year and a half or so, have gotten to know Matt just as there really only a handful of attorneys in the community who were brave or foolish or I don't know, crazy enough to voice our opinions on things. And Matt was one of those people who always had great insights. And as we thought about the theme for this week, and actually I want to thank True Name for kind of a prompt here as we were talking last week about the accessibility scope and what would the appropriate advisors be for accessibility. I thought there was a really interesting, correlation there, synergy with the scope topic we're looking at this week, which is physical resiliency. But instead, again, as I mentioned, instead of getting into the maker specifics of it, this conversation with Matt, and I'm going to stop talking in a second, with Matt as our guest. And if you read the meeting notes for today, I kind of teed up a little bit why we thought he'd be a great person to share with us, what's being discussed on the world stage as far as decentralized finance, a Web3, the metaverse, because really, if we're going to come up with policy for Maker, if as a ABC, we're tasked with developing the advisory councils, it seemed like a good use of this hour to look outward and hear about, what are these issues that makers needing to navigate. And that's a very, very layered conversation. It's not just legal and regulatory per se. There's sort of many ways that we are thinking about physical resiliency from a technical, a policy, a cultural, structural, all of those things. So here we want to become smarter, Matt, about what the lawyers in our sector are talking about, are worrying about. And you have been very involved we both are located in the same state in the US, in New York. And so I just really wanted to invite you to, maybe take 10 minutes at the top and introduce yourself to those who may not know you, how you got involved in this first of its kind symposium that was recently held here in New York. And just give us sort of a 10-minute overview, and then we can maybe get into some more specific topics, and of course, really welcome others to come on the mic and ask your questions or comments directly to Matt. So take it away, Matt.
Well, thank you. Thank you for the invitation to be here. I appreciate it. For those of you who don't know me, I hope I'm coming through loud and clear, by the way, because if I'm not, please stop me. My name's Matt Feinberg. I'm an attorney and a dad living in New York. I got involved with Maker almost 2 years ago and was actually possibly going to become a delegate, although it just didn't work out and there was so much going on at the time. Um, but yeah, I'm an attorney practicing, amongst other things, emerging technologies. And about 7 months ago, maybe at this point, maybe a little longer, the New York State Bar Association's president, um, Shari Levin Wallach, created a task force to look at, and at the time, she called it New Emerging Digital Financing Currency. And now it would be probably something different, just because at the time that's kind of what the focus was, even though we've been dealing with many other things. And I was a member of the task force shortly after she formed it and was appointed a co-chair. There's three of us, and we've been having a lot of meetings, but we've also been having interactive in real life functions. We had an event. It wasn't for CLE credit, continuing legal education, but we did have it. It was free in December at NYU. It was also live streamed. You probably could find it on State Bar's website. If you look at the task force um, website, there should be some links there. And then recently, we had our first global symposium where we had participation and contribution from bar associations all over the world, ranging from Barcelona, Guam, including a footprint across the US from New York, California, sections of the ABA, American Bar Association. So it was really great. We had guests come in and be present um, to speak. Guests came from Guam, Turkey, uh, England. It was really exciting. The Bahamas. It was just a great opportunity to get together. That was a CLE, which was for continuing legal education. So we had more attorneys come, and the idea was to kind of prepare the bar, prepare lawyers for what's coming, because there's a large spectrum in terms of attorneys and what they know and what they don't know, ranging from a high level to an attorney who just doesn't want to have any knowledge or have anything to do with blockchain, crypto, Web3. Those words, they hear it, they run. So, we're trying to educate the bar, ranging from somebody who's an obstructionist and just doesn't want to listen, to somebody who gets it and is actually, working in that field. And it's been exciting. It's been rewarding. And we have other stuff planned for October. It's going to be a part two, probably in New York, probably at NYU, involving more AI and the law. But yeah, it's very exciting. And one of the other things that we do, I created a POAP for the event, which was fun because it gives the members of the bar an opportunity to kind of play around with blockchain technology. And I thought POAP was a good idea because they're very much like, they don't want their tokens to be put on mainnet. They kind of want it on their own thing, and it felt secure enough where I would get people, attorneys that were somewhat resistant. I could say, well, here's POAP. They kind of pride themselves on not being involved in any financial aspects of it. So I had a friend who, as a member of the Bar Association in Florida, designed the POAP. So we had attendees could get the POAP either virtually or in person, which is a great opportunity to engage the bar, explain the tech. And we also are involved on legislative topics. So New York is an important state. There's pending legislation or legislation about to be introduced by the New York State Attorney General's office. There are other congressional representatives from New York that have pending legislation. So we're also engaged with legislators trying to explain our position and what we feel is the best for attorneys and attorneys in order for attorneys to serve their clients. What do we see as a strength? What do we see as a weakness? Um, so it's exciting to be on that forefront and hopefully, being able to make an impact on the future.
Well, it's great to hear that perspective, Matt, because I think, what attorneys do, how the work of attorneys is structured, it's not intuitive. We are facing, quite an environment globally, but I think it's not just about what the actual rules are or what the requirements are, and from a decentralized finance perspective, how to operate in a way that preserves the values of MakerDAO, the permissionlessness and the privacy and security that DeFi offers. We're going to need to rely on lawyers, right? I mean, to not only represent business and the businesses, but also to understand the technology and what we're doing, both those that are, kind of potentially representatives of groups or participants in the MakerDAO ecosystem, but then also those who would be on the other side of regulatory action and, the policy environment around the world. So here I'll just read, we have a winning hearts and minds. That's exactly right. So Jan Sky has put in the chat, did the symposium address the potential impact of physical disruptions or disasters on the functioning of the accessibility of the metaverse? Were there any noteworthy discussions or debates on incorporating resiliency measures in the design and operation of metaverse environments? And I might just add on to that sort of that's a really interesting point about like force majeure. I wonder if the conference talked about the business operational side of this, or was it more kind of regulatory and enforcement focused?
Well, so I was a co-chair and co-chaired um, the breakout sessions on the first day, and I can explain what they were. The first panel, there were three that ran simultaneously. One of them was pertaining to IP and copyright and stuff arising, in the Web3 space. The second one was what do I, and this is an important one that, a lot of attorneys and people don't realize, especially attorneys, what do I do when my client inherits, comes upon cryptocurrency through a divorce, through an inheritance? What do I do if I have, no knowledge of it? The other one at that point, was I don't know if it was the smart contracts panel or the tax panel, but there were IP, smart contracts, and also tokenization of real estate. Can you, what does it mean to own real property or realty on chain? Is it possible? Those things. So I don't know that, and I moderated one of the panels regarding tax, but I don't I don't recall hearing anything about that. It may have been, and then on Saturday there were additional sessions regarding regulatory, criminal. I feel like there was something almost on risk mitigation, but nothing really like a panel targeting that. That may have been, mentioned in passing. While it's extremely important, um, there wasn't anything dedicated to that. This is basically uh, in order to get people that are not familiar, and also people that are more familiar, but to get attorneys that are not familiar with anything, to get them involved at a very low level, and to be able to really just get them to see what's coming in the future. I will say that in New York State, effective July of this year, all attorneys every 2 years when they have to register as part of their CLE requirement. It's different in terms of new experienced attorneys and non-experienced attorneys. I want to say after 2 years of practice, you're considered experienced. So that's basically most, a lot of them, a lot of the attorneys. You have to have a certain amount of credits regarding um, cybersecurity and ethics, which is a move in the right direction, because we just have a lot of attorneys that are stuck and kind of a little bit behind. So I'd love to be able to get to the point where we can really discuss, uh, more preventative measures, but we just weren't there yet. But that's a good topic to possibly address in October.
Well, I think you're bringing up a point that certainly for all the builders in the space and everyone on the call is to appreciate, you know, when seeking advice, right? We're as an organization building out a bench of experts, advisors, special advisors, and to realize how far behind in many respects the conversation or the knowledge is within the legal community. I mean, you have a group of crypto focused lawyers, some are very active on Twitter, and they maybe represent a particular demographic. You and I are frequently, I mean, I'm frequently noticing you on a weekly Twitter space that's, I think, a Rug Radio broadcast where some great conversations are had by crypto attorneys. But I wonder, Matt, if you could talk about, what are some of the qualifications then, as you describe this effort to educate the bar, and the question about whether such a grouping of attorneys is even yet sophisticated enough to begin to think about the issues of physical resiliency that, say, MakerDAO is grappling with. Um, you know, where do you see the pitfalls, or how to navigate selecting or vetting a qualified attorney? Like, could you talk about the maturity of the space, and how to where those gaps are, and how would we identify um, attorneys who are maybe capable at this stage of where the technology is?
Well, I would say, I guess, classic response is it all depends. Typical attorney response, and of course, none of this is legal advice or financial advice. But it really, depending on what you're looking for, you really need to keep an eye out for a few things. If you're looking for something that is going to be relatively complicated, touch upon areas that are really unsettled, I think it's always a good idea to try to find a firm that's on the larger side, that has various practice groups that, whether they realize it or not, hopefully they do, they can handle a lot of your needs. And that's a thing that I've noticed, and that we try to explain to firms, that a lot of these firms that are, quote unquote full service law firms that do basically normal stuff and represent businesses are almost already equipped to handle more work in this space. Now, of course, they can't just jump right in, but they have, firms that have everything from corporate governance practice groups to, I mean, gosh, everything. Every practice group dealing with every industry, imaginable. So you really want to find, I guess, rarely is it just one lawyer. because I think it's fair to say any lawyer should tell you that they're not they not an expert, but that they can't be able to represent every interest you have. It's something's going to be out of your wheelhouse. You're going to need to go here or there. You're going to need to have the support of a firm, and is it two attorneys that are just doing a couple things, or is there a support staff? How many attorneys do you have? If there's an emergency, can you pivot and have the strength of that firm, of the infrastructure, come and help a client in a moment's notice? Those are the types of things you want to look for. Now, sometimes it's cost prohibitive, because the larger firms, you can cost more. But like I try to tell a lot of people, and a colleague of mine, Pablo Segarra, was just sent a tweet about this today, saying how important it is to spend the time and the money on the front end, in terms of, he was mentioning it regarding terms and conditions and that type of stuff, because you don't want to have to deal with litigation, because first of all, there's no guarantee that you're going to win, and you may spend a lot of money and lose, and have to pay, God forbid, the attorney fees for the other side if there's some fee shifting provision, by statute, or if it's in a contract. So there's a lot that needs to be taken into consideration. There are a lot of attorneys out there that hold themselves out, as doing work in the field. I don't think there is a true quote unquote crypto attorney. Um, I don't know what that is. You can have experience in certain things, but and general experience in certain things, but you would want to find out, I guess, more about the person's experience, what they've done in terms of non-crypto related stuff, because to an extent it's not that much different. When you're talking about defense work, and you're talking about uh, having a lawsuit, it's going to be pretty similar. We may have some new things, but at the end of the day, it's probably going to be the same. So
Core
it's
competencies, yeah.
right. It's just going to be substituting different facts, but it's going to be so and so did this and it harmed me, and that's just the way it is. So it's definitely important to be careful. But if you're out there and engaged, you should see the attorneys that are at least putting in the time, publishing, hosting spaces like you mentioned, LexLine, with Carlo D'Angelo and Ray Janko, uh, where it could range from a couple of attorneys just talking about developments in the space that day to hosting a guest, um, and going from there. And then there are other spaces too, and there are other people to follow. So if you do your own research, usually you can find the good ones, the ones that know what they're doing, and certainly with respect to Maker, if you're somewhat familiar, you just ask the person, or you just can ask the attorney, do you have any familiarity with DeFi or DAOs, or whatever the case may be. But it
Matt, on
definitely
that
gotta
topic,
be careful.
so with DeFi, and whether this was covered at the conference or you just have thoughts, representation when there's no legal person, right? And conflicts of interest. So just wondering, if was that a subject that was covered at the symposium? And what are some of the things people are saying in the field about their comfort with representing DAOs or decentralized finance, or how should the community be thinking about those topics? Lawyers, I think what's non-obvious a lot of the time is that your code of professional conduct has some pretty unintuitive rules about how you can do work and how you can hold yourself out as an attorney. And so some of that breaks down when there's no actual client that maybe represents MakerDAO as a whole. And of course, you're familiar with different structures, ways that makers kind of got around that to get work done. It's not easy. But can you comment on that, on the the technicalities of representing a decentralized organization, what conflicts of interest look like when you're an attorney
Yes,
potentially seeking to provide services to decentralized finance?
we did have a ethics panel. I don't know if they discussed this, although it's recorded and it's all part of it if you registered. So I'm not sure, but that's obviously a huge issue. Um, I think, like you said, people have figured out ways, uh, I guess, around that. For me, I think the real difficult issue is when you don't know your client, not just who is your client. Is it a facilitator, whatever you want to call it? Not just that, but if you don't know the identity of your client, because like you said, we have to do certain things like conflict checks. We have to make sure that if we're going to be taking on representation of somebody, that there's no conflict, that we didn't take a position that's adversarial to that person at some point, because as an attorney, you have a continuing duty of loyalty even to former clients. That's why you can't go out there and just, oh, it's a former client, I don't care. So those things are definitely important. Now, I've seen cases where attorneys have represented quote unquote John Does without disclosing their identities. There was a case where somebody was served pursuant to NFT. It was in New York. I don't know what happened to it. It was a couple of months ago. But one of the issues was, can you establish jurisdiction without providing the identity of your client? Now, the attorney maybe knew who these people were, and that maybe was how they were able to get over that hump. But you have to, if depending on what you're trying to do, you may have to prove jurisdiction. How do you do that? If you're representing a DAO or an entity of a DAO, you got to carefully think about that. So yes, that's very interesting, and it's super fact specific, and it's almost ever changing with just the landscape of the international landscape, and how things are going on a rapid basis. Yeah, that's definitely an exciting point.
Well, a big part of physical resiliency is the use of privacy, anonymized identity. And there was a call earlier today, a community call talking about it's called Tool House Rocks, where we cover different technologies that the ecosystem may want to adopt. And part of the product offering was a way for participants to be anonymous but yet import their blockchain credentials. So for example, you could kind of register as a user with a fresh blockchain wallet, but with ZK proofs, you'd be able to share that you'd voted on a particular maker proposal in the past. Um, you know, without, I guess, going into a lot of the end game reasoning, in that world where an ecosystem, a protocol that's designed to run forever, and as we get through this pregame and bootstrapping, really harden a simplified core. And then, of course, then there are these layers of the sub DAOs. And you know what? You and I had a chance to catch up last week, and we talked a little bit about the new sort of Galaxy decentralized version of Maker. Uh, how does that work? Representation, and is that, do you think that this is like maybe a key area that the advisors or advisors to the DAO should really hone in on, um, what new risks or what new operational challenges in terms of enforcement of laws or protection, the protections that the ecosystem wants, that I think Maker structurally is thinking about for the whole organization, not just on the regulatory issues, but also on business issues, just purely on the business issues, and also on uh, not just defense but offense. Would you say that anonymity, the technical anonymity, which we think is important for resiliency, raises like a special category of legal considerations that require special expertise?
Probably at this point. I mean, just going over right now, thinking about, the conversation that we just had. If I want to act affirmatively on behalf of a DAO, um, where am I going? Where am I, how am I gonna establish standing? Yes, those are all important things. And I think in terms of on the attorney representing the client aspect of it, our ethical rules are just very old. And as I've been researching certain areas of this, you know, it's obviously lawmakers and rule makers are slow. There are advisory opinions coming out regarding representing clients more in this space, but I haven't seen many actual rule changes. And we have to operate within those, rules, or else we can lose our license, and that means, that's bad. So, it's all about doing what you can, making sure it complies with your ethical responsibility, and still balancing what your client wants. If you can't, now you have to just, this isn't legal advice, but you really need to explain to your client ethically what your responsibilities are, what information you need to know from your client, and what the ground rules are. That could be everything from accepting cryptocurrency as payment to everything else. Full disclosure. If your client is not happy with the way that you're proceeding because of your ethical constraints, then the client has to go somewhere else. But we have to operate within the law, and within the code of ethics, which is even more, I want to say more stringent, but can be more thorny than the law itself. And so we're dealing with, as attorneys, we're dealing with, law created by courts or legislation that's behind, and we have ethical considerations that are behind. And that's part of what at least the bar association is trying to do and trying to speed it up. But I will tell you, it's baby steps, and it's difficult, and it's all about, long term. So I think that's keeping that balance of anonymity and privacy, um, is super important. And that's why certain software was created, not to be used to evade, but for privacy. Because even on the blockchain, even where we have transparency, we do need some sort of privacy. I think most people understand that, maybe don't agree with that. Although I believe in that personally. I think other people have things that they don't necessarily want everybody to see, whether it's their compensation or other, information. So there's certainly need for that. And I think going forward, that's important to keep in mind when, the stakeholders in whatever jurisdiction they are getting together to craft ethical considerations, at least, what an attorney can do or can't do, or whether they're writing advisory opinions on what attorneys should and shouldn't do when operating in the space, because that's what we're constrained to right now.
Well, there's certainly a lot of politics going on that, don't necessarily speak to the merits of taking one position or another, or whether we're factually correct on interpretations of laws. But as you're speaking, Matt, it strikes me that, Maker is in a really powerful position to be able to, convene, I think, through the structure of the councils and the kind of research work that it wants to do, these kind of like it's not philosophical discussions, but when you get to the level of, what are the attorneys ethical obligations, and the creativity that's really required to confront some of the intersections that pose new challenges, having that done in a way through Maker doing its research, and then its entire ecosystem, and not even just the sub-DAO ecosystem, but then, all of DeFi is following what MakerDAO does. That then that study can now actually benefit the entire industry. And so I wonder if you think that that's useful, a way to think about, from a policy perspective, in terms of Maker's approach to resiliency at a governance level and physical resiliency, and how it interacts with attorneys, that we might be talking about not just, all right, here are the facts of this particular case, but that we actually also think about this broader, like, well, where does the entire profession, how does the entire profession need to evolve and explore, these intersections that then can maybe, I don't know, move the needle or inform. You talked about writing or other kinds of, I wouldn't say necessarily lobbying per se, but, the thought leadership. Like, what kind of thought leadership do you think Maker is well positioned, as well as kind of like from the lawyer side of it, culturally, like, where do you think the two groups could kind of come together around thought leadership and, moving the whole dynamics of the legal profession forward, so that we can actually implement safely all of the physical resiliency measures that we think are crucial for the final vision of Maker?
Well, Maker is the industry standard. So anything that Maker can do and do successfully is going to be copied. And that's just, I think, the way that it's going to be. So if there's an avenue to show the greater community um, how how everybody can work together, um, I think that would certainly catch on. And I think there's a tremendous opportunity there just with Maker. There being a lot of attorneys, a lot of leaders in the community that have spent countless hours thinking about these issues, and writing about these issues. But Maker's in a position now with the end game and everything coming together and addressing where we are now to lead the way, and could certainly uh, you know maybe move the needle in terms of actual legislation. I hope that would be amazing. But absolutely, I mean, that the goal is, to avoid having to have somebody get hurt where our legislators, enact legislation. So someone doesn't have to get sued in order for there to be case law. So someone doesn't have to be physically harmed or financially harmed for there to be some action. So if we can say, hey, look at what MakerDAO is doing, look at what they've done, look at this framework, look at what they've thought about, and what's been going on, and assuming we're seeing obviously good stuff coming out of that, then I think that's a much easier sell to legislators, and then they can wrap their head, because a lot of it is, a lot of people just can't picture it, and they just don't get it. And I don't think that's just limited to attorneys. I think it's that's for a lot of people. A lot of people that are making decisions and policy don't really understand until they can actually see it in action. And once that happens, I do think that that's a great opportunity for things to get rolling.
Jen, comment, and also if there's anyone who wants to come off mic, ask Matt a question or share a comment, you're welcome to speak on these meetings or add something in the chat. But her, their question: in the context of decentralization, what are the potential ethical implications of prioritizing resilience over other factors, such as privacy, security, or inclusivity? That strikes me as kind of a bit of a tough question, depending on how you're defining those things. But maybe, Matt, could you say a little bit more what you mean by ethics? Like, attorneys' ethical obligations are a very specific kind of a thing. And so maybe one way to approach that question is say a little bit more about what does it mean to have an ethical obligation as an attorney. And it's really, it's really about the client representative. It's about vigorous advocacy for a client. And I would say not so much about the ethics of how they make business decisions. The ethical obligations of a lawyer are more about the purity of the advocacy of the attorney being your agent, and not really necessarily taking a moral view or an ethical view on what you decide to do as a business matter, but just making sure that you're fully informed as a client. And because of the nature of that advocacy, the profession has tons of rules about what you can and cannot do with respect to doing work for a particular client. That would be my take on the when we talk about ethics for attorneys, how it's a little bit different than I think the common sense interpretation of that.
Well,
What would you say about ethics?
maybe in the question, I guess um, I could use the example just as like for resiliency or privacy or security where you want to remain anonymous and your name, you don't want to give your name for what to your attorney, even though your even though there's no formal exchange of currency, you likely have an attorney client relationship that's stronger than a priest, stronger than a religious confidentiality. But anyway, nonetheless, if you don't want to, and that's understandable, for everybody's got their own feeling. Some attorneys, and I'm of this mindset, and this may be where an ethical consideration for an attorney becomes more important than the, I don't want to say privacy of the other person, but it's just like if you want to remain anonymous and just be a wallet number, like I said, the problem with that is using today's system, you can't run a conflict check. If I don't know who you are, I can't tell whether or not I've sued you. I can't tell whether or not I may have been in a relationship with somebody who was thinking about suing you. I can't tell if you're somebody who I can't represent, for a myriad of reasons. So that's just the system that we live in right now, where we have names and for conflict check purposes, attorneys really, at least this is the way I interpret it, and I don't know how there's really a way around that. In order to do a proper conflict check, which you need to do, because you need to make sure you need to have undivided interest with your client. You can't, it's the most important, the most sacred relationship, an attorney-client relationship. You have to know that you're taking on a matter with a client that you've never had an adverse relationship with. That's just, the rules. So without a name to run a conflict check, you can't really you're not supposed to represent that client. And that would be, I guess you could argue, to the detriment of that potential client's privacy. Again, there are cases, and I people that take on cases and they know the identity of their client, but they're not disclosing it at a certain point. They may have to because there may be court orders, but there's reasons how you can get around that. I'm just saying the example that I gave, even from the beginning, that's an initial hurdle to even an attorney necessarily taking a case, just because you need to do a proper conflict check just to make sure, because if you don't and something shows up, um, you could get into a lot of trouble. You could lose your license, amongst other
You
things.
don't know you don't know who you're representing. And so to Code Knight's question in the chat, what is the best way to phrase questions for lawyers in MakerDAO so they feel most comfortable answering? So with this,
Well,
I want to actually also ask you to explain a little bit more, what is attorney-client privilege? Like, what is that relationship? Because I think it's, we're in a tricky position when things are asked of us in a chat or just asked on the forum. An attorney is not allowed to give legal advice unless there is a written agreement and you actually have a client and you're representing a particular client. So it gets very difficult, I think, when, to your point, not just sort of an anon that wants to hire a lawyer, but from MakerDAO and the community's perspective, receiving legal sort of opinions on the forum. And so I do want to hone in on exactly what Code Knight asked there in the chat, but also, like, if you could explain a little bit, Matt, what is attorney-client privilege? Like, what is that unique relationship between an attorney and a client that then allows a lawyer to even start answering questions?
right.
And what
So
are the constraints? Yeah.
right. I see the question. So it's an attorney-client privilege, and it's the attorney-client confidentiality. So in order to have all the confidentiality attached, you need to have that attorney-client relationship. When you have that, that is your attorney. You can tell that attorney almost everything, and that attorney can't disclose that under most circumstances. Um, an exception to that is what we're seeing right now with Donald Trump, the crime fraud exception. Rarely used, but they hauled his attorney in there to give testimony. So, in order to have that, certain things need to be in place. Now, one of them is you need to have a relationship, and you need to have an expert. If you're an attorney and you're going to give if you're going to give advice that is going to be um, remain confidential, you can't give it on a forum because there's no expectation of privacy there. So that's first. So I don't see a way, unless it's a private forum with clients, and those are the clients. But if it's an open forum and anybody can see it, nobody would post anything there with an expectation of privacy. So you wouldn't get anything there, most likely. And yes, usually you're not going to be able to get legal advice from an attorney on a forum or in that fashion, because we're stuck with these ethical rules. We need to know who the client is or what the client is. Is it a corporation? Is it a business entity? Is it an individual? Are they multiple individuals? Because if you're representing more than one person, you normally have to disclose a potential conflict there. And that and to the extent, and if at some point in time your clients have divided interests, you have to get new counsel for sometimes all of them. Sometimes you have to get out, and everybody needs their own. Sometimes, so it can get very messy. So that relationship has to be established, in order to get the benefits of that relationship, and that's getting legal advice that you can rely upon, advice of counsel, that you can rely upon to conduct your business, to conduct your work. An attorney told me this. I will retain this attorney. Confidentiality, stuff that other people aren't going to see, legal advice, questions. So
Well,
that
Matt,
typically comes with it.
you said the magic word reliance, which was on my mind. Who's entitled to rely on this advice? And I feel like this is like such a thorny area here, because as you've been explaining, the relationship is particular. Undivided interest with your client that's reduced to a writing, preceded by all kinds of conflict checks, like, I've never been a lawyer for somebody whose interest was against yours in the past, and if I have, I've gotten a written waiver. All these things come together, and then you represent the client, you have the relationship, and then you produce some advice based on that relationship and fact. What does it mean for others to use that advice? And what's the danger for those who are adjacent to the client? Or what's the danger for the lawyer involved if others rely on that advice? And, we're doing that every day in Maker. I guess the lawyers involved have gotten comfortable. There's the different disclaimers. But where do you see that issue? How do we confront that issue of relying when you're not entitled to rely on anything a lawyer has said unless you have paid for them to be your particular lawyer?
Right. Well, then I would argue that's an extremely tricky question, and that's a question of fact that I'm not sure has been litigated. But if you wanted to, like, for example, there's an advice of counsel defense. It's a defense that's used in many jurisdictions. It may be used in a prominent case in the U.S. shortly. But it's when, hey, my attorney told me to do this, and it's used basically to negate the intent that you would need to establish that the government or that the prosecuting agency, whomever, would need to establish the intent that you needed to. So this is a real defense, but typically you need to be the client, and like you said, you need to have those elements. When I'm retained, you get a client bill of rights in New York State. You're in order, you're supposed to give a client bill of rights, which explains what the client's rights are and what the rules are. You don't do that. So I would say that advice that's given in a open manner where anybody can see it is not your, there is whatever client had that could rely on. I mean, I don't, it's maybe it's still advice of counsel. It's not confidential anymore. But maybe that one client only gets that benefit. I see somebody mentioned a law firm. uh, but yes, I mean, these things happen all the time, and we're going to see that in the FTX case. And if you want an example of that, it's going to be a little bit different, but you're going to see some resemblance of that. Now, I don't believe that was mentioned in the criminal case where it was a motion to dismiss. But I would presume, should the case go to trial, and some counts I think eventually will survive, that's going to be a defense. That's going to be a defense. What that they use, advice of counsel, and it's going to be, again, there's going to be a motion in limine probably saying, well, you can't use that because you weren't the attorney, you weren't the client, so it's going to be real. It's going to be likely briefed. So you're listening to me. I'm like getting excited about motion practice. It's kind of pathetic, but yeah, this is the life that I live. So
Love to see
so
it.
yeah, we may see this actually briefed. In a it's not a DAO, right? Because it's a different context, but it's going to be new, and it's going to involve certain aspects that cross over into where Maker kind of, may cross over as well, and it will be a good premiere just to see where we're at and to flesh out the topic if it gets to that point.
Out a burning question, that maybe could be our last question. If others, have final things they'd like to hear Matt speak to, please put them in the chat. So in terms of Maker or decentralized finance, and I don't recall in which action the SEC sort of claim this or where it's connected. I'm sure, Matt, you'll remember. The hiring of attorneys was viewed as a fact to prove centralization. Do you know what I'm referring to? So it's sort of one of these enforcement actions, I guess, against a DAO. I'm not sure which one.
Maybe the
And
Okie
the
Dow.
hmm?
Maybe the Okie. I don't know. You say Okie, I say Okie. Maybe that one.
That was the CFTC more so, but anyway, the substance of the point, which is kind of cute, kind of clever, like it's like, oh well, if the DAO has hired a lawyer, then the DAO must have some people, or it must, if you're decentralized, how can you hire lawyers, right? Is sort of I guess, the flip, off the cuff argument there. And so I just wondered if like you'd honed in on that particular claim that was being made. And again, I can't off the top of my head. I'll follow up in the Discord chat after this. But just wonder what your thoughts are there. Sort of like, okay, well, we can't win for losing. You're in a rock and a hard place. Yes,
I
of
don't know
course,
about.
human beings are
Yeah,
are doing things to cause things, but to say that, if you don't get a lawyer, then you don't have the advice and you don't have any protection. And yet, I mean, this is like a really interesting potential threat if this were to get legs anywhere in the world, that, oh wait, you've got a lawyer defending you, so therefore obviously centralized. What were some of the arguments that, I mean, I'm putting you on the spot here, but surely there's a way for something to pass a legal test or an actual test of being decentralized, and yet somewhere, somehow within that, lawyers are able to advise other humans about their conduct.
well, I think I know. I don't know about an SEC action, but that CFTC matter, that the Okie Dow. I want to say the judge, in terms of notice, whether there was sufficient service. I think, amongst other things, said, well, there that there was a couple of amicus briefs, and that's not even the lawyer. That's a friend of the court writing a brief, and they were kind of just inferring, like, yeah, well, you guys, everybody knows what's going on. It was, this was click, this was clack. It's very difficult. But yeah, I mean,
I mean,
that is.
definitely a tough environment where our physical resiliency depends on probably being smart about the implications of laws and regulations, and then the very act of retaining counsel, even the way you go about hiring for counsel. Now it's like we have to take a even further step back as we think about our resiliency policy of, like, it's not just like, okay, we got to hire lawyers, and it's like, okay, well, pause, think about, really, really, really think about the structure and who and how governance interacts with permissioning, and designing any of these relationships. I mean, it's just incredibly thorny thicket of issues.
Yes, it is, and the courts are just seeing it as no different than any other. They're seeing it as an uncorporated uh, partnership, and that's just the way that they're seeing it. And uh, you know, uh, maybe with better legislation, even the stuff now that we see in the states, really, I don't think sufficiently cures that. But yeah, I mean, that's one of the major issues that I guess we're always dealing with, and as a litigator, it's very difficult to address these things. I mean, in certain situations, you can, like, for example, if you're contesting jurisdiction, um, you can make a special appearance where you're not necessarily conferring jurisdiction. You're not giving into jurisdiction on the court. You're not saying, okay, here I am, I'm appearing in this action. I'm just making a limited appearance to say that I wasn't properly served.
Mm.
But it's very hard, and we're dealing with an antiquated system, and a lot of it is just substituting different facts. And until there's additional, clarity in terms of uh, better laws that don't overlap and don't conflict, at least in the U.S., this is what we're stuck with.
Great. Well, it's top of the hour, Matt. Thank you so much for joining our meeting and sharing your perspective and experience. And thank you everyone who's joined the call. We've got a really big group today. So if there's nothing else anyone wants to say as we wrap up, that will be it for Refi ABC, and we'll, engage a little bit more on the substance of the MIP and some of the governance business asynchronously that we can take away from this conversation. Look forward to hearing from the delegates, what sort of insights maybe this conversation might have sparked as we are, trying to address the advisory council that we'll need for the physical resiliency scope. All right, everybody.
Thank
Have
you,
a good
everybody.
day.
I appreciate the invite.
All right. See ya. Bye.